Sunny, were you able to check up about that insurance? This thing was anything done or not?
Insurance aspect.
Insurance aspect. You have to get back whether under that paragraph of the judgment whether the government did, because as informed yesterday, it appeared you had not done it. This is what Mr. Parekh was saying. I just wanted to know, is that the fact? Only as a matter of fact. You've not done it.
No, it's a fact.
Okay.
My lords, the learned Attorney General has laid out the facts and the conspectus of the case. And during the course of arguments, certain reports and studies were referred to in his list of dates. My lords, these form the basis of our arguments, and we invite this court to take a slightly different view of those reports and facts on the law. My lords, I have handed over a very short note.
Yes.
The structure of my arguments will attempt. The structure of my arguments, my lords, will attempt to lay a foundation based on a gross miscarriage of justice and then build on it squarely within the technical aspects of the law as it stands today. But my lords, perhaps first things first, who are we? I am not an NGO. I am not third parties looking to, or busybodies looking to do good at best or at worst profit from the survivors' misery. I am the survivors themselves. I have 5 organizations of survivors who have organized together in various respects. The first organization is, in fact, a trade union of a factory that was set up by the government in order to provide some employment and some succor to the survivors. My lords, if I will have a very brief time, if I could just...
On the papers referred to in the note,
my lords,
papers filed by them, which are
my lords, I will come to all of it. I'm grateful for the protection. So, my lords, this factory was set up to provide succor and employment, whatever employment they could do, because there wasn't so much that they could have given the health damage. And the first organization, for example, is a trade union of those survivors. There are other organizations. One is widows, disabled survivors, others who are claiming welfare benefits as survivors, banding together and supporting each other. All of these, my lords, was laid out in IA 729, and IA 729 was first allowed without any conditions. And at that time, I was 11 years younger, and Justice Lalit was then a senior advocate, was leading us in the criminal curative. And pursuant to those submissions, the court examined the issue and said, very well, and this is the order, my lords. My lords, in fact, in a lighter vein, I was briefing Justice Lalit in an entirely different matter, in a matter in which our client was, had allegedly committed all sorts of terrible crimes. And he said, I was reading about that matter and I would like to help you. And that's how he came in. So, my lords, at the bottom of page 2, is the revised order.
Yeah.
Interlocutory applications numbers 7 to 9 are allowed, subject to service. And that was the part that was not read out on Monday. Issue notice on the maintainability of the interlocutory applications and merits of the matter. Previous to that, my lords, was the order.
And see, your problem is you are constrained by certain part of legal history which has happened. And it's difficult to go beyond it. So one of the issues is that at the relevant time, the courts upheld the norm that the government really stepped into your shoes
Absolutely.
and filed a claim. Once they step into the shoes and that provision is upheld,
Yes.
there cannot be a separate channel of your representation that look as if they have not done the job which they're supposed to do. We are faced with the scenario of a much later scenario of a curative petition. It's not an original petition which we've been telling the learned attorney also. So now, having settled it for A value or B value, whatever it is, nothing prevents them from doing more for you. We are not saying they should not do more.
That I'm very grateful for, my lords, that we will be not left without anything because and demonstrate the hardship that's currently.
They can do more for you. They apparently have not done something which they were supposed to do for you in view of
many things. The governments over there are many.
So, but in this matter, we are only our issue is only this: can we, on part of any of your interests,
Yes, Manoj.
pass on anything on them? That's the government stand. That we
Absolutely.
recover from them. Who stops the government from doing something, or from you from saying, "Look, the government should do this more"?
Yes.
That's the difficulty. How do you say a settlement subsists,
Yes, Manoj.
but it's kind of like top up the settlement? So that's the whole issue. Can we top up the settlement? This is there.
My lords, in fact, the survivors are relying on now on the documents that have been placed by the learned attorney. And what we are merely...
We can't, see, we said in the beginning, we
Yes, sir.
cannot look into documents, whether of the government or yours or anybody, post what had happened at that stage of time, because it's curative. So the difficulty arises, we can't forget this side that what jurisdiction we are exercising.
Absolutely.
And we are
Of course.
by that jurisdiction.
Of course, my lords. The curative jurisdiction is exceedingly limited. And perhaps when we filed originally our application for directions, we asked for the world and we sought too much. So now what we have done today is that we have limited our plea to what has been falling from my lords and to what we see as falling squarely within the technical considerations of the curative jurisdiction, as my lords have exercised in the only 4 judgments that have allowed curative. And we will demonstrate why the gross miscarriage of justice, which is a very, very high standard, is perhaps met here. My lords, if I may go to the structure of our arguments so that I myself don't get derailed, by going on too much about a particular point given. Now, my lords, the second point in the structure, this is on the top page, is that it is now settled law under the law of absolute and strict liability that private profit-making enterprises that use hazardous material in a profit-making activity will have absolute and strict liability for any damage that stems therefrom, and including the example is given if a gas escapes. This principle, and the judgments say this, also exist in significant part because these enterprises have exclusive knowledge of the makeup of that hazardous material, the toxicological impact of any damage that is caused by that hazardous material, the mitigation and the ameliorative possibilities that can then lead to any medical care, categorization, etc. Number 3, there is no other way to say it. We tried in conference to find other more gentle ways to put it. But my lords, a fraud has been played on this honorable court, on the Union of India, and on victims. In the first part, it is because there was a suppression of material facts that go to the root of the settlement. The first study, internal safety study with regard to methyl isocyanate, was commissioned and obtained in
Madam,
1974.
is the fraud period as a ground in curative petition?
My lords, in curative petition, there are three.
No, we are asking a very fundamental
ma'am.
question. You are intervener. You are.
Yes, ma'am.
Is fraud pleaded as a ground in curative petition?
My lords, fraud is pleaded as a ground in our impleadment application that my lords had allowed. All of this is there. We are only limiting it. We have not extended it. We are only limiting it, my lords.
The problem is this, you see, in some way, you are doing piggyback on the curative petition file. Otherwise, you would not be, intervention would not be. So, when you seek to piggyback, then you can't go beyond the four corners of what the curative means. You are in a way supplementing that.
The attorneys.
Look, this is a curative petition. We are the affected party. Being an affected party, therefore, look to our point of view also. But that point of view will have to be constrained, as my brother put it. The four corners of a curative.
Yes, ma'am.
So, and the whole problem is that if, now, for example, your point 3.4 is fraud resulted in wrong categorization of injuries.
Yes, ma'am.
This is something to be done by the concerned authorities there. It's nothing to do with that, in a sense. Fraud resulting in undercompensation. Again, all this would require, as we said earlier to the attorney also, saying you reopen the whole case, start the trial again. This is the consequence, unfortunately. And what kind of evidence one would lead? You are saying there are some evidence in terms of documents nationally available on their conduct. Okay. But to what extent that conduct affected the people involved is in evidence. It'll be an unmanageable affair, much as you may have a point.
My lords, what we have attempted to do is to propose the cleanest solution that we could imagine in the circumstances. And my lords, if I may just be permitted to go through the structure,
Yes.
and we'll address all the questions when we come to the.
Yeah.
So, my lord, suppression of material facts is an internal safety study, and the Carnegie-Mellon study that they had, two studies that they had commissioned, says specifically that there is major and residual injury caused even when a small amount of methyl isocyanate is inhaled. Now, my lords, I will demonstrate all of this, that this is, of course, the inverse of minor injury. And in a top secret meeting, which we obtained by RTI with the government, the top secret meeting with the government that Union Carbide had sought, back in 1985, 2 months after the Bhopal gas disaster, they proposed categories of minor injury, of temporary injury connected to work. And these categories were made their way as is almost in the scheme, because of course the union would rely on the companies. Now, my lords, coming to the next point here, that per the experts and the ICMR reports, the injuries resulting from MIC exposures are permanent. Now, my lords, the ICMR, which is the apex government body for medical research, realized the permanent nature of these injuries and indeed the progressive nature of the minor injuries, of even the mild exposure. Because now those cohorts are dying at a much greater rate than the normal population. In 2004 and subsequently, in 2009, which is when their reports came out, because they did not have the benefit of the many toxicological studies that the company that had exclusive knowledge had done, and to this date, they have not disclosed those studies. What we obtained through the very rigorous United States discovery process, where no documents cannot be suppressed. The second we obtained through the Environmental Protection Agency, even though Union Carbide had said to them that please do not, this is confidential, do not disclose this document because it is our property. We have that document. My lords, the next point is that 25,000 rupees is what 93% of the victims got in the first round. And then Justice Muralidhar was leading for these 5 groups that I am now representing before me. In 2004, he came to my lords, and my lords had given another 25,000 rupees in order to disburse the rupee devaluation amount as well as the interest that had accumulated. So the vast majority of people, 93%, and this was read out by Union Carbide also, they have relied on this figure, have got 50,000 rupees over a lifetime of cancer, of liver damage, of chromosomal defect, which comes to about 3 rupees per day. Now, my lords, coming to point B. The settlement consisted of 2 portions, a civil and a criminal. The review judgment is a final determination of what justice will mean for me, for the victims of this gas disaster. That review judgment was concerned with the settlement, which I will be addressing in the first part, and it was also concerned with the criminal. Counsel for Union Carbide then had invited the jurisdiction of this court, citing the Sancheta judgment under Article 142, saying that the criminal cases against Union Carbide can and must be quashed or withdrawn as the union had then proposed. And this court said no. This case must be investigated, that the criminal cases must go forward, and at no point did Union Carbide say that you do not have jurisdiction over us. This argument is without prejudice to jurisdiction. In fact, they were saying you have jurisdiction over the cases. When the decision went against them, my lords, 2 days later, Union Carbide said to the press that this court, our courts in India, had no jurisdiction over them. And 2 months later, they were declared proclaimed offenders. They were declared absconders. Their co-accused were convicted. And today, they are proclaimed absconders. So my lords may consider whether the fugitive disentitlement doctrine enables them to say anything without submitting to the jurisdiction of the magistrate's court and or depositing some monies before this court should the judgment be against them. My lords, at point C, a US court has found that UCC was evading, this is a federal court, the District Court of Connecticut, was evading the attachment order that was subsequently passed by the Magistrates Court in Bhopal to compel their presence by setting up a web of companies, intermediaries called Mega Visa and etc., in order to supply their intellectual property and other goods to this country and for those properties not to be attached. My lords have, of course, understandably been concerned with the fact that what happens now, and what's the point of this entire exercise? Why should 5 judges of our courts exercise themselves then when what is going to happen if the settlement is set aside? My lords, today, the only thing that we are asking my lords is to unravel the fraud and to set aside the settlement. 3 things could follow, depending on what my lords feel about this. The most obvious would be that the interim order would be reinstated. The Madhya Pradesh court had found prima facie liability of the Union Carbide Corporation, the American corporation. It then said, in the review judgment, my lords have said that should the settlement be set aside, that $3 billion worth of unencumbered assets must be maintained here. Unclear whether they'll do that or not. And that the union must return the amount of the settlement to Union Carbide and others. But my lords, there have been analogous incidents of in pari delicto in the past. Why should the taxpayer suffer the burden of this, even of the settlement being unraveled, if it is found that a fraud has been played on the court? In Loop Telecom, and I'll take my lords through this, the current Chief Justice, sitting with two others, had found that the doctrine of in pari delicto means that when two parties to a contract have exchanged some benefits and one party, at the very least, has committed an illegality, then that is an exception to Section 65, and then that party need not make restitution. They can keep the benefit under the contract. This was in the context of the 2G fee, the license fee that was paid. The third option, my lords, is to look at a Mareva injunction. A Mareva injunction is, the application was made, my lords, everything has been served on them many, many years ago. In fact, we were before Justice Arun Mishra, and we had with the then Attorney General collectively said that could they consider this first, and there was a wedding in the family of, and he said we'll consider it on the next occasion. Now, my lords, the Mareva injunction is founded on a few things, including the frauds played upon this court and the fact that they're, I beg your pardon.
Mareva injunction against what?
Mareva injunction saying that they must, if they are to be heard, then they must deposit a bank guarantee.
The whole concept of Mareva injunction is you withhold some assets
Yes, my lord.
may move out of the
Yes, my lord.
court's jurisdiction.
Yes, my lord.
What is the asset they have here against which Mareva injunction?
But they can be called on to either deposit a bank guarantee.
They are very clear. See, Mrs. Sadu was very clear in the beginning. We are here to assist the court, but we are not bringing a penny more. So, what is the asset which can be, according to you, when you talk about a Mareva injunction? To bring that asset here. See, the Mareva injunction is utilized. Sometimes the shipment is there, some ship is going by. You detain the ship under a Mareva injunction concept.
That's where it originated.
That is where it
And
originated.
and from below.
If there is no injunction, there is nothing to be taken out or taken in, then where will Mareva injunction be?
Fair enough. Fair enough. In this context, then only what remains in the Mareva injunction context is that Mr. Philip Lochner, who is the former Securities and Exchange Commissioner in the United States and a professor of law now, he has placed an affidavit before my lords in this case, once briefed on this case, and he was shown documents, to say that it is unlikely that any judgment against them will be, it will be difficult to satisfy, and hence they should deposit a Mareva injunction is supportable and they should be called upon. And he also said that there is a distinction.
But
Lord, I am giving the Mareva injunction.
only one thing.
Not wanted to come in my way.
Please remember that you are not arguing the original suit.
Yes,
We are in a very, very limited jurisdiction of a curative petition filed by Union of India that also is not filed by you.
yes,
So therefore, there are some constraints on that.
yes, ma'am.
We are not arguing, we are not deciding the original suit.